Hey friends, good afternoon. It's Nikki Jackson coming back to you live from Orlando, Florida. We are at the WCI Live Podcast Experience, and I'm so excited to bring you two guests today. We've got Zach and Liz with Holder Paget, Little John, and Prickett LLC. Thank you guys so much for coming on.
Yeah, thanks for having us, Nikki.
Yeah, so I know you guys are focused in the Carolinas. Whoop, whoop, shout out. I'm from Rock Hill, South Carolina, and frequent North Carolina often. So tell us a little bit about yourselves.
Sure. Well, I'll go first. My name's Zach Jarrett. I'm in the Charleston, South Carolina office and handle exclusively workers' comp claims in South Carolina.
I'm Liz Wiles. I'm also in the Charleston HPLP office with Zach and exclusively do workers' compensation. I'm licensed in South Carolina and Georgia. And I also do Longshore and Harbor Workers' Compensation Act claims when those come along.
Wow, great. Yeah. So you guys, after you graduated, you got into law school, you picked workers' comp off the bat?
Kind of fell into it, actually. So my story is I was going to go into dental school and then ended up going to law school instead and interned at a workers' comp firm. Ended up really liking workers' comp and everything that it was about and took a job there straight out.
Okay.
So, workers' comp kind of found me straight out of law school. I was a judicial law clerk working for a circuit court judge. So I saw a lot of criminal trials, a lot of civil trials, decided I really wanted something different, not a jury trial experience for my career. Found a workers' comp firm, fell in love with it, and here I am several years later.
Awesome.
Yeah, we were actually in the same law school class. So we're 10 years out this year. Crazy.
All right. Well, congratulations. We're excited that you're here and helping to protect our employers. So What is the latest? What's happening in the Carolinas?
All right. Yeah. So we got a lot of things going on. Something we're seeing really common right now is some fines for various forms.
What?
I know. We're getting a lot of notices from the commission on unfiled Form 12As, late Form 18s. It's a $200 fine, and we're getting those a lot of the time. So those are pretty hard to appeal if they just weren't done. But if there was an error on that side, we can usually appeal and get those overturned. But the commission loves a fine, so.
Yeah, so be wary. That's a 12A, so first report of injury, a Form 18 periodic report. So those have to be filed timely. They really don't take many excuses for why those aren't done, especially now that we have electronic filing by email. Really no good excuse for those to be late.
Mm.
Yep.
What else?
Yeah, another thing that recently came out in the last year is we've always had the direct deposit option, but now direct deposit is mandatory unless the claimant opts out, and that's for TTD payments, the direct deposit. So whenever a claim's initiated, you're supposed to send the claimant a form for them to fill out for the direct deposit information and go from there, and they can opt out of that and prefer a mailed check, but if they don't, then it has to be direct deposit.
Is this an old-fashioned, like send in the mail kind of form?
You can do it however. Usually they do mail it, but they can fill it out electronically. It just depends kind of on the sophistication level of your claimant. So that varies, obviously.
Oh, all right. Anything else?
Yeah, so we've actually had a couple case developments. I'll talk about a case that's come up recently called Crowley versus Darlington County. So in South Carolina, the defense, employers, and carriers, we have certain restrictions on how we're allowed to communicate with physicians' offices. Historically, if the claimant/patient had not established a relationship with a treating doctor yet, we had a lot more leeway in how we could communicate with that doctor. We did have to provide contemporaneous notice to the claimant and their attorney if represented, but if there was no established patient-physician relationship yet, we just had to do that. We did not have to give advance notice. When this Crowley case came out recently, it now has taken on for the position such that no matter whether or not the claimant has seen this doctor yet, we must always provide 10 days notice of the communication in advance to the claimant or their attorney. So that's definitely something for employers to be wary of if you're trying to get return to work restrictions for a claimant, and then insurance carriers, if you're setting up IMEs, those independent medical evaluations, just be really cautious about making sure you're following the case law and the regulations on communicating with physicians appropriately.
Oh, okay.
Yeah. Another case that came out recently is the Braley versus Michelin case. And that case focuses on a lot of things, but the takeaway is a fraud in the application type of defense. So we see that a lot, and that would appeal to both employers and adjusters to know about. So the real takeaway is whenever you're hiring someone, it focuses on what you can and cannot ask them about their prior medical conditions. So the courts are starting to say that those pre-employment questionnaires might be running afoul of some ADA guidelines. So you have to be careful on what you can ask. And long-standing law in South Carolina has been a fraud in the application defense, which essentially just means that someone concealed a prior condition, the employer hired them based on that misrepresentation, and then otherwise they would not have hired them. So in this case, they're saying that they don't think that defense can hold up much longer because it's hard to make a misrepresentation about something that they weren't allowed to ask you about in the first place. So the court hasn't specifically addressed it, but that's what that case talks about, and they remanded it back down, and they're going to address that in future case law, they said. So,
wow. All right.
yeah.
So this is the 79th Workers' Compensation Institute Conference. I think next year is year 80. And one of the things I love are all the sessions and, of course, the networking and the charitable things. But a hot topic is still AI. So can you talk to us a little bit about some insights or trends there?
Sure. So same with our firm, AI is coming up a lot. We're talking about it. We've looked at various, file management systems that might consolidate some things, summarize things for us. We haven't implemented any of it and aren't actually using it yet. I attended the Defense Trial Attorneys Conference last month, and the commissioner spoke about AI, and they're very hesitant to open that door. They use an example of a lawyer who submitted a brief citing, I think they said 10 cases, and 8 of the 10 cases didn't even exist at all when they tried to go check it. So I think it's a developing situation, but I have to be a little careful on what it says in there, because I think sometimes what you're putting into AI is trying to please you by what it's giving back, and it might not necessarily be true.
Yeah.
So.
Right. And I think besides that, we also have some privacy concerns, right? These AI generators, you just want to make sure if you're investigating using that you are following all types of privacy rules, especially I know a lot of applications are coming up about using AI to summarize medical records. Obviously, that could have great benefit for folks. But of course, we want to be really cautious about making sure that when we're putting that information into AI, that other parties do not have access to something that would be protected by HIPAA, that we should not be disclosing. It would violate some of the ethics rules, right? So just, I think, a cautionary tale. Definitely see the advantages to it, but we need to be careful about how we're using it.
Oh, it's so scary to think that people could be out there uploading medical records into ChatGPT or something.
Right.
Oh, it's crazy.
Social security numbers, all bank accounts. Yeah.
The stuff that keeps CEOs up at night, I'm sure.
Right. True claims nightmares right there.
Well, and historically, I mean, we have to lock our files away, and we have codes on the door for this information. So it's kind of scary to think we're just inputting it into a system and hoping for the best. So I think there's a lot to figure out there.
So are you guys heading back tonight?
We are going back tomorrow. We're staying for the third day, the Workers' Comp Defense Institute, WCDI.
Okay.
We have a multi-state breakout tomorrow where we'll be focusing on each state individually.
Okay.
Yeah.
Well, if you're still around, I don't know what those times are, but the Alliance of Women in Workers' Comp is also doing an event tomorrow morning.
Yeah.
So feel free to stop in for that. We're all in this year. That's the theme.
Okay.
Any final thoughts or comments?
I mean, we're having a great time here, so it's been good. If anyone out there has questions for us, we're happy to help.
And how can we get in touch with you?
Yeah, I think email's great. I'm E.Wiles, W-I-L-E-S, at hplplaw.com.
Yeah, and I'm zjarrett at hplplaw.com as well. And our website, hplplaw.com. We'll have all of us on there, so take your pick.
Okay.
Yeah.
Well, thank you again for coming on. It was great to see you both representing the Carolinas.
Yeah.
And to you out there watching, stay tuned. We've got more podcasts coming your way. See ya.